All right, well, we might get started. So good morning, everyone, and welcome to the latest installment in CHU's ongoing series of webinars. Today's session is all about liability claims and is presented in partnership with insurance law firm Gilchrist Connell. Now, we all know how complex liability claims can be, and applying those within strata just adds to the complexity. So I really hope that today's session will give you some great tools and knowledge to use while talking to your clients about liability claims. For those that don't know me, my name is Vincent Norton Scott. I'm the Technical Claims Manager at CHU, and today I'm joined by Melissa Fenton, Principal at Gilchrist Connell Lawyers. So in the spirit of reconciliation, CHU acknowledges the traditional custodians of the land on which we live and work throughout Australia and their continuing connection to land, sea and community. We pay our respect to their elders, past and present, and extend that respect to all Aboriginal and Torres Strait Islander peoples. So the agenda for today is that I'll kick off with a quick update on CHU liability claims, and I'll also touch on a few recent trends that we've been seeing. And then I'll pass over to Melissa for her presentation. Please feel free to ask any questions that you may have in the chat. Today we're joined by CHU's liability claims lead, Louise Cook, alongside Candice Ingleton of Gilchrist Connell, and they will be answering your questions in the chat. If we have any time available at the end, we may be able to take one or two questions live. And just in relation to questions, please bear in mind that there may be some questions that we can't answer in this forum if they're too specific or if they're heading towards providing legal advice, but we will do our best to answer any questions in a general way. And nothing in this session should be construed or relied upon as actual legal advice. Just a little bit about CHU's claims service. Our claims team is the largest and most experienced in the strata market, consistently demonstrating a commitment to service and excellence. Claims is the engine room of our business, and it represents more than 45% of our operations. Within claims, we have 77 people situated across Australia, plus a support team of 7 based in Manila, and we're backed up by CHU Services, who have a team of 49 assessors and consultants that we often use on our claims. Earlier this year, we were very proud to win the Insurance Business Claims Team of the Year. And coming up on this Thursday night, we're actually up for another Claims Team of the Year award, this time at the Australia and New Zealand Institute of Insurance and Finance Awards. We're nominated alongside some of the really big players, including IAG, Allianz and Chubb. So we're definitely punching above our weight there. And I've certainly got my fingers crossed for that one. CHU are also nominated for Underwriting Agency of the Year. That'll be our 3rd year in a row if we win. And also for the Excellence in Environmental, Social and Governance Change Award. So fingers crossed we will get all 3. I'd like to introduce our expanded liability claims team. 2 years ago, this team consisted of just 2 staff, and obviously we've now grown to a team of 5, which is reflective of a couple of things. One, the increase in claims that have been coming through, but also just our commitment to service and to providing a really strong and responsive team. Last year, we brought on Louise Cook as our liability claims lead. Louise has over 17 years of experience in public liability claims, including working as a lawyer, acting for insurers. We've also got Jerry, Helen, Ron, and Vicky, some of whom have legal qualifications, and all of whom have significant claims and strata experience. I'm very proud of this team. It has to be one of the strongest liability claims teams in the strata insurance market. This team handles predominantly public liability, office bearer liability, and legal defence claims. And we are supported by CHU's extensive nationwide panel of law firms, which of course are available to your clients through the claims process. Before I hand over to Melissa, I just wanted to touch on just a couple of trends that we've been seeing recently. One is an ongoing increase in claims resulting from water ingress. These are obviously leading to claims for damage to lot owners' property, ongoing loss of rent claims, etc. And that probably flows on to the next trend, which is a real lack of urgency that we're sometimes seeing in dealing with maintenance issues. And I know Mel will touch on this in her presentation, but I can't emphasize when you're talking to your clients the importance of quickly dealing with defects in maintenance, because something quite small can often lead to a very expensive and drawn out liability claim. We're also seeing an increase in claims for legal defence expenses. We're seeing a lot of lot owners and tenants and other parties taking owners' corporations to tribunals. Perhaps that's reflective of society becoming a bit more litigious. And finally, I wanted to just raise, we're often seeing a notification, we're often seeing a delay in claims being notified to us, and that particularly applies to legal defence claims. And I just point out the risk of owners' corporations potentially prejudicing their claims by not reporting them quickly enough, particularly when it comes to legal defence claims. Please let your clients know to report straight away, ideally before they start incurring any costs. Okay, it's now my pleasure to introduce Melissa Fenton. Melissa is an accomplished insurance lawyer with close to 30 years experience. She specialises in advising insurers and professionals on multi-party litigation and dispute resolution with a focus on general commercial insurance claims. Melissa defends a variety of general liability claims against entities, including owners' corporations, builders, contractors, retailers, and commercial premises occupiers. Her expertise in general commercial insurance includes advising on personal injury matters, as well as property damage, subrogated recovery claims, strata and community title disputes, and coverage litigation. From defending large-scale litigation to managing small claims matters, Melissa represents a diverse group of professionals, owners' corporations, occupiers, landlords, and SME business owners. Melissa is known for her commercial approach. She identifies the real issues in dispute and engages with stakeholders to resolve claims efficiently and fairly. Over to you, Mel.
Thank you. Thank you, Vince. Thank you for such a warm welcome and a generous introduction. As Vince said, I have the pleasure of talking to you, hopefully demystifying liability claims, and focusing a little bit on the Policy 2 claims, which are all about liability. For those of you who are less familiar with liability claims, but mainly deal with Policy 1 type claims, a quick way for you to get your head around what the Policy 2 claims deal with is Policy 1 claims are generally related to first party loss, and Policy 2 claims are third party loss. That means a claim by somebody else for compensation against the insured, in this case, the owner's corporation. If we go to the next slide, Vince, I've got just a snapshot of what we're going to cover today. I'm going to begin by giving you a quick overview of the CHU Policy 2 liability to others and explain the types of claims that will generally trigger that policy. We'll then move on to a little bit more granular detail about those categories of claims, being personal injury claims and property damage claims. As Vince identified earlier, there is definitely a trend of an increase in property damage claims being brought under Policy 2 and generally being litigated in MCAT. And we'll look at those claims, some of those claims, and we'll look at why that might be happening. Generally, when you get a claim against an owner's corporation, it's for some kind of breach of duty, whether that's the statutory duty that's imposed by legislation, or whether it's negligence, which is considered the common law duty. We'll then also look at how you can, in your role as a stakeholder in this whole chain of community, how you can help manage the life of the claim so that you help to resolve it quickly, contain costs, and ultimately have a happy client. And we'll finish off at the end with just some risk management tips that will also be useful to try to avoid claims in the future, or when you can't avoid them, to at least minimise the cost and disruption that they cause. If we move on, thanks, Vince. So policy 2 here, you can see it provides cover if the insured becomes legally responsible to pay compensation, and that can be compensation for a personal injury or property damage that results from an occurrence in connection with your ownership of common property. While each state and territory has different legislation, it's mandated in all states and territories that owners' corporations have residential strata insurance. The policies must also cover liability, hence this policy 2 cover for liability. Important to note, it also costs the cover of defending a claim. Now, Vince was saying there's been an uptick in legal defence expenses. I have a couple of theories about why that has happened. One in particular is, and we'll talk about this when we talk about NCAT and how it's got jurisdiction to manage claims and resolve claims in strata disputes. It's becoming a lot more legalised. So in my experience, it used to be a no-cost jurisdiction, and it was very user-friendly. And by that, I mean lawyers were not really encouraged to participate. That has changed. It's morphed over time, and there are more and more lawyers getting involved. And as a result, expenses are being incurred, and then it's coming back onto the policy. Something to just bear in mind. What do claims look like that might trigger this policy? Well, it's usually a complaint or a letter of demand that the owner's corporation receives, or the strata manager. And it's usually a complaint or a demand saying that someone has suffered loss and that they hold the owner's corporation responsible for that loss. What do you do? Briefly, if that happens, you notify your broker and CHU as quickly as possible. As Vince mentioned, there are often situations where there has been a delay in notification, and that can be quite critical, firstly, into how quickly the policy can respond, and secondly, in how well we can actually investigate and defend the claim. So let's move on and start with personal injury claims. These, unfortunately, don't really have a rhyme or reason in how they are notified. So I've just put on the screen here some different ways that you might be alerted to the fact that there has been an injury or an incident at the premises. You might be in the first category there. You might have somebody who has actually been an eyewitness to an accident, which often takes the form of a slip and fall. I think in strata living situations, there are common hazards which you'll see as we go through the cases are quite obvious in hindsight. Things like worn floor coverings, broken tiles, holes or cracks in tiles, speed humps and wheel stops are often causes of hazards where somebody might slip and fall. Sometimes poor lighting might create a hazard, uneven or damaged floor surfaces, and sometimes even poor housekeeping of the premises. So if somebody does unfortunately have a fall and there's an eyewitness, you might be lucky enough to then to be immediately notified, either a committee member or the strata manager. Sometimes that doesn't happen, and perhaps the first you'll hear about a claim is receiving a letter from a solicitor's office asking for preliminary discovery. So those letters, if you have not received one before, are generally a letter explaining very minimal detail that so-and-so fell on such and such a date. Probably that's the amount of detail they'll give you. And then they'll ask for you to provide any CCTV footage you might have from that day. They might ask you for all of your records about maintenance and repair. They might ask you for any incident reports. The list goes on. And then the letter will generally finish by saying, if you don't provide this information, we're going to go to court to get an order for it and recover costs from you. So they can be quite intimidating letters. If you receive one of those letters, again, pass it directly on to the broker and or your insurer so that they can help you respond to that in an effective way, and also make sure you're not handing over material you don't have to. The third one on the screen is receipt of a letter of demand seeking compensation. So that's, again, a letter from a solicitor saying, or maybe even the claimant directly saying, I fell down your stairs, I've incurred some medical expenses, and I hold you liable. The final category there is you actually are served with a court proceeding, which we call a statement of claim. And that's usually, once that's happened, you need to act very, very quickly because there are certain timeframes by which defences need to be filed. And you can really prejudice the owner's corporation's ability to defend a claim if that's not passed on really quickly. So let's keep going. How can an owner's corporation be liable such that policy 2 is triggered? In the examples I just gave you in relation to slipping and tripping on common property, that could be an allegation that you've breached your duty of care. If you are also, you'll see on the screen, it's Strata Schemes Management Act. There's also, and we'll talk about this at quite some length, there's a statutory duty to maintain and repair common property. So allegations for personal injury claims are often also based on this statutory duty, and allegations that the owner's corporation's failure to maintain or repair certain items of common property have caused the person to fall and hurt themselves, and therefore entitle the injured person to receive compensation. I won't go into detail about the Civil Liability Act. I just put it in to highlight that there is a piece of legislation which dictates how compensation can be awarded. And generally, when someone brings a personal injury claim, there is what we call heads of damage about different pieces of compensation they're entitled to. And it might include things like loss of earning, loss of income, past and future. It could include treatment expenses, both past and future. It might also include domestic care. So if somebody has been significantly injured and relies on somebody else to help them with their general day-to-day care. And it also includes something that we call non-economic loss, which is a sum of money that that piece of legislation governs for pain and suffering, effectively, because the person has been injured. So they are the mechanisms. I've also just highlighted at the bottom there are also duties under the Work Health and Safety Act, but I'm not going to be talking about those today in the context of personal injury claims. Something I wanted you to know, and we can keep this slide, most of those claims where there is an allegation of negligence or breach of statutory duty causing injury, they generally commence them in the New South Wales District Court, sometimes the Supreme Court, but the District Court here has jurisdiction to hear matters up to $1.25 million. So your general slip and fall type claim will fall within that category. So let's have a look now at this case example. I couldn't find a photo of somebody slipping on tiles. So even though the case involves tiles, you've got boards in the picture. So in this case, Miss Riley slipped on a ramp which formed part of the common property. The ramp was directly exposed to the weather, and at the time of the accident, it was raining. Miss Riley claimed that she slipped on a lubricant, or she says water, that was on the tiles that caused her to fall, and that as a result, she injured her left foot, her heel, her ankle, and her lower back. She brought proceedings against the owners, and she claimed that they were in breach of their obligations to maintain the common property, and that they were also negligent in specifically having tiles on a pedestrian surface that were not appropriate. So she had engaged an expert that did slip testing of those tiles, and that expert determined that they weren't suitable tiles for wet weather. One of the issues that the judge had to decide was whether the tiles were in fact wet or dry at the time she slipped. Importantly here too, the owners also brought a cross-claim, which is they sued somebody else. They sued Abbey Group, who actually constructed the ramp, saying that, well, if the tiles were the wrong type of tile, then we will seek to recover from the builder because they were the ones who determined the tiles. Ultimately, for Miss Riley, she didn't give evidence very well, and the judge decided that she didn't have very credible evidence. It was quite inconsistent. So what the judge found in this case was that, in fact, the tiles weren't probably that wet, and so the judge didn't really take heed of any of the expert evidence and decided that the tiles weren't wet, and she just slipped because she had failed to pay attention to where she was walking. Miss Riley was pretty unhappy with that and appealed. She, and this is the Court of Appeal decision, she said one of the issues that should have been considered by the initial judge and wasn't, was that the owners corporation, she said, had a duty to monitor the tiles, and if they had evidence that those tiles were not suitable for that walkway, they should have actually upgraded and changed the tiles. And that because they didn't have a proper inspection regime, they should be found negligent. And it's important to note that in that case, the owners couldn't produce any evidence of a regular inspection program. So there was no evidence before the judge about what the owners were doing to manage the risks of pedestrian surfaces. On appeal, the judge said, actually, I think you're right. The owners should have had a system of inspection, and they've breached their duty of care by not actually identifying that those tiles were unsuitable and taking action about it. Lucky for this owners corporation, though, the judge found that her injury was so small, the judge said she sprained her ankle and had one day off work, that she wasn't entitled to any compensation anyway. So that's one example of how the courts approach these. On the next case example I have, it's a situation where a high heel got caught in a hole in a tile. So Miss Borg was at the Quest Apartments in Cronulla, and she, at the top of the stairs, tripped up when her heel got stuck in the tile, and then she fell down the flight of stairs. She was celebrating her 30th, and it was at about 1 a.m. But before you jump to any conclusions, she was breastfeeding and wasn't drinking alcohol that night. So she sued the owners corporation, and she alleged that the hole in the tile was a hazard, and that it was up to the owners corporations to identify the hazard and rectify it. The court held it was a hazard and it should have been rectified. A complicating factor in this matter was that the strata plan, I don't know if you know the Quest Apartments in Cronulla, but it's a 12-storey building. It's a big complex. There were 3 separate strata plans, and together they all retained a building manager under a BMC to manage the property. And what the court found was that the building manager was also liable because they were directly retained to manage these risks. So liability was shared between the owners corporation and the building manager, 80% to the building manager, and 20% to the owner's corporation. Moving along, and it should be noted that Miss Borg was awarded over $500,000 for her claim, plus lawyers' costs. The next case I'm looking at is not in relation to a strata complex, but it is really similar in terms of the facts because it involves a wheel stop. Now, I and other colleagues of mine in our Queensland office as well, we have multiple claims, some currently involving wheel stops in car parks, also speed humps. I have a claim at the moment where a lady has alleged the speed hump wasn't sufficiently differentiated from the floor surface of the car park and she tripped. So this case, you can see the wheel stop. Mr. Jacob went to KFC for dinner with his partner. He actually parked where that disabled spot is on your screen. And he alleges they had dinner, he came back out, and the picture on the left, if you can see on your screen, there's a very, very thin red line. He said that was the path he took to go into the passenger seat of his parked car. And then when you look at the photo on the right, you see the black line. He's effectively saying he went around the car that was parked at the time, went to go into the passenger door, and then tripped on that edge of the wheel stop. So he sued KFC and he said that they had inadequate lighting, and because of the inadequate lighting, he fell on the wheel stop, and that was a failure of them to maintain their premises, and they were negligent. The court found that it was an obvious risk. The evidence actually revealed that he had been to KFC multiple times and was well aware that there were wheel stops. The court also said because it was an obvious risk, the KFC didn't owe any duty to warn him about the obvious risk. And that is an established piece of legislation which says if a risk is so obvious, there's no need for you to take extra steps to highlight that risk to patrons or entrants on the premises. Compare that to Miss Borg, whose heel got stuck in the hole. That wasn't an obvious risk because it was nighttime and it was a very small hole. So poor Mr. Jacob didn't end up getting anything. The court also did say if they were wrong on the finding that it was an obvious risk, his contribution to his accident was 100% because he failed to pay attention to where he was walking. The next picture I have is just one that I wanted to highlight. Again, I have multiple claims, as do some of my colleagues in other states, involving grates which are broken, like the one in the picture, or just unstable because they're missing covers. And this is a high risk for personal injury. So I just wanted to highlight this, just saying this is going to be a critical thing for you or to when you're telling your clients how to manage their risk, is to manage all surfaces and common areas, including car parks and drains and grates. Something to be mindful of as well, to prevent personal injury claims arising on, say, a grate like this, you really do rely on all of the residents or tenants, managers and contractors to be reporting defects. So you really, I think, want to encourage your clients or owners, corporations to have or to implement a system of reporting so that they can capture, people who are on the property all the time are best placed to notice things like this. And if there's a portal or somewhere where they can go to notify, that would be really helpful in terms of managing the kind of risks that create claims. I'm going to finish up with personal injury claims shortly, just giving you the life cycle. I wanted to explain, there's some data by APRA, which is the Australian Prudential Regulation Authority. They released a report last year in May, and they provide all kinds of data about claims, and the ones that I was looking at in the report were personal injury and property damage claims. The report said on average, a claim for bodily injury has an average cost of about $130,000. That's about 6 times more than your average property damage claim, which is $20,000. So these claims, the personal injury claims, whilst not as common as the property damage claims, are certainly very expensive, and they're also quite time-consuming to go through from beginning to end. I should add, we finish here on the timeline with a trial, a hearing. I think some commentators have said less than 5% of these personal injury claims actually go to trial. So the cases that we just went through, just to give you a feel for how these cases happen, they all did go to a trial before a court and people had to give evidence, but that's not the usual outcome. Most cases do resolve before then. So here we've got, it starts with a statement of claim being served. We talked about that right at the beginning when we talked about how would you be notified that there was a personal injury claim, or how did we know someone fell over. If you've got that statement of claim, it's really important to pass that on quickly, because we have to file an appearance to let the court and everybody know that we are appointed as a panel lawyer, and then we need to request particulars of the claim. It's also at this time that we would be in touch with the strata manager and a committee member, and we would try to gather as much information as we could so that we can respond to, and if appropriate, defend the claim on behalf of the owner's court. We have to put on a defence, and the timeline is 28 days after service of the statement of claim. If you don't put on a defence, the claimant can actually approach the court and ask for a default judgment. So it's really important that we take steps quickly and before that happens, so that they know that you're going to defend the claim. So part of us managing this is also educating the committee members about the seriousness of the court proceedings. You'll then see we go around to the right-hand side of your screen. The usual course is there's a pre-trial conference. It's usually within about 2 months after the statement of claim has been filed. At that time, we would generally get timetable orders from the court about service of evidence. So the injured person would generally get evidence from doctors. If there's a fracture or a break, they would probably get evidence from an orthopedic surgeon. We often see people serve occupational therapist reports, which talk about their capacity. Sometimes we also see psychiatric reports, because often they will allege that they've got psychological sequelae as a result of the injury. Bearing in mind too that the cost of these expert reports can go between $5,000 and $10,000. So each time they're getting more evidence, it's getting more expensive. You'll often find too, in the case that we talked about with Miss Riley and the wet tiles, often the plaintiff or the injured person will get a liability report. So they might get an expert consultant engineer or other safety expert to have a look at the site and then make a decision about whether it was a hazard, and also make comments about steps that the owners could have done to avoid the risk of injury. Something to be aware of too with the experts, they generally also come with a request for a site inspection. So you'll have to, talk to the Owners Corporation Committee about making the premises available for the experts to go and have a look. After the pre-trial conference and timetables are made for the service of evidence, there's usually a status conference, and that's when we all go before the court and talk about whether we're ready for the matter to be set down for a trial. Now, in my experience, it's at this point we start to have negotiations with the other side, and the court will often order that the parties attend what we call is an informal settlement conference or a mediation. And we use best endeavours at that point to resolve. If you can't resolve, then the matter is listed for hearing. and negotiations can continue, and sometimes hearings are inevitable. Sometimes we have a really good case. So, for example, the KFC case, I would be very much of the view that that needs to be defended. A wheel stop is required as part of the Australian standards. So what are you supposed to do? I know in some cases, the a clever plaintiff lawyer will try to get around those kind of arguments by then complaining about the lighting. But I think there are a number of cases which show people do need to take personal responsibility, and sometimes if you can't reach an agreement, you will end up just going to trial and trying to present your case in court. I think that is it in terms of the general lifespan of a personal injury claim. As you see, they're slow, it's very time consuming, and it can be very stressful, particularly for committee members if they have to give evidence or help us with statements. But it's generally something that can't be avoided unless there are some good systems, which we'll talk about towards the end of the session. So I'll move on now to the different class of claims, and you're probably all completely triggered by the picture of the water damage there. We're going to start talking about property damage claims. These are the bulk of Policy 2 claims that we see. I know everybody participating today is well aware of all the extreme weather events that our community has encountered over the last decade. I know Vince spoke about it. And I know too, there were those huge storms in New South Wales in both 2020, 2022 and April this year that as a result, the number of water ingress claims has absolutely extremely, it's just gone out of the extreme. So it's no surprise then that most of these claims relate to water ingress. There's also many, many claims that arise out of unsatisfactory waterproofing. It doesn't always just have to be weather events, though. You can also get water ingress when you've got another lot owner who might be renovating their kitchens or bathrooms. The most common kind of areas are leaking plumbing taps and pipes, ruptured water pipes, deteriorating roofs, faulty gutters, building defects such as inadequate waterproofing on balconies. And you all know that once water starts seeping into the building, it starts damaging the structure. And if these, and Vince mentioned this as well, if these issues aren't addressed quickly, the ongoing water penetration just continues to incur further damage and then ultimately further cost. So the general way that these claims come about under the Policy 2 is it'll be either a lot owner complaining that there's water ingress, and as a result, they have lost a tenant, and so they allege a loss of rent, and they seek compensation for those losses. The key term is compensation because that's what triggers Policy 2, not just the property damage. Most of these claims, unlike the personal injury claims, which we talked about, which are generally in the district court, most of these water ingress claims are managed in the New South Wales Civil and Administrative Tribunal. So let's have a look at how these claims have exploded. This is the key section. I am pretty confident that every single one of you are familiar with this section. This is the section that imposes upon the owners corp the duty to maintain and repair their property. You can see the key sections are subsection 1 and 2 on your screen. And this duty, well, this piece of legislation has been heavily scrutinised by clever lawyers and the courts, but it's now very well established that this duty to maintain and repair is compulsory and it's absolute. So it's not a duty to use best endeavours or to take reasonable steps. It's a strict duty. There's no grey. So As a result of this strict duty, the minute there is water ingress into somebody's unit that's come through common property, the owner's corporation will be in breach. The critical thing about once they're in breach is that last section on your screen, which is subsection 5. And that section provides that if a lot owner actually incurs a loss that's reasonably foreseeable because of the breach, the owner's corporation must pay damages. So this is the critical, and this is the section that sees most discussion in NCAT. And so we'll have a look at that in a little bit of detail. When we talk about damages, so we talk about compensation, what we usually see in the property damage type cases is its rental loss. So a lot owner might have a tenant in there who moves out because of the damage. There may be alternate accommodation expenses. You might have a lot owner who has to move out because the damage of water ingress is so significant. You could see a claim for compensation for costs of cleaning and carrying out repairs to the apartment, the lot property. We are seeing, and we touched on this, an increase in legal costs. So that's also falls within that section. And expert fees. So as you would also know, trying to investigate and determine the source of the water ingress can be really difficult, and you might have multiple experts giving opinions. All of those things can also be claimed as compensation by the lot owner. So what is the usual process or life of these types of claims? Well, as I said earlier, they go generally through NCAT. NCAT won't hear a claim or won't let you file an application unless you've attempted mediation with the New South Wales Fair Trading. So I'm sure many of you will be very familiar with that process. The fair trading mediations have varying degrees of success, but it is supposed to be voluntary and determined by a neutral mediator, because as we also know, with the complexities of strata living, there are a lot of different stakeholders and a lot of different personalities. So having access to that neutral mediator can be very beneficial. It's also very cost effective, and you shouldn't really need lawyers at that point. So that's why the NCAT procedure is you start there. Assuming the mediation fails, then what you'll see is a lot owner filing an application with NCAT. That application, you have to set out a little bit of factual material about what's happened, and then you have to put in the orders that you seek. And what we see generally is orders for carrying out of either rectification or remedial works. And we also then see orders seeking compensation, which would take the form, like I mentioned, loss of rent, costs, and so forth. At this point, it's really important to notify your broker or your insurer that the NCAT application has been filed, because once there's a claim for damages, policy 2 may be triggered, and it's important to get the assistance of a panel lawyer. The tribunal doesn't allow lawyers to appear automatically. You need permission to appear, and it's certainly been my experience over the years that that permission is more likely to be granted, and it's almost guaranteed that you will be allowed to have a lawyer if the claim is worth over $30,000, or if it's considered to be complex, or if the applicant themselves has a lawyer. So moving on now to what a claim might look like. I've got 2 examples here, which are both decisions that have been determined by the tribunal. The first one involves slurry, and I'll just give you some brief facts about that case. The applicant, so Mr. Miraforidis, had a tenant in his unit, and he'd arranged $550 a week to be paid to him for a period of 6 months. Unfortunately, the unit or the lot above him was carrying out some renovation there was a problem and slurry and water entered into the applicant's lot one night. That was the 5th of October in 2021. So this isn't really a storm weather event or a burst pipe. This is just renovations gone a little bit awry. He immediately notified the strata manager and the building manager on pretty much the same day. And then the next day, he received a note from his tenant saying that because of the slurry and the water, I can't live here at the moment. And in fact, just because of my job and my cat, it's not really suitable for us to stay here if builders have to come in and fix all of the damage caused by the slurry. So I'm going to break my lease. So the lease was broken, and then the applicant sought to recover from the owners the cost of the lost rent and also the repair works for the lot. The Owners Corporation took the view, and I'm sure this will not be surprising to many of you, that it wasn't their responsibility because, in fact, it was the lot owner above the applicant who was doing the renovation work that caused the slurry to escape. The Owners Corporation said to the applicant, you need to talk to the lot owner above you to sort this out. The lot owner above was not that willing to resolve it, if I could say that. So the lot owner above was agreeable that, yes, there had been some slurry, but he thought the damage was quite contained to a small area, whereas the applicant was explaining that, in fact, the damage was a lot greater. So there was almost a three-way dispute. The applicant, who suffered losing his tenant, wanted someone to help him fix it and to pay for the loss of the tenant. The Owners Corporation decided it was the lot owner doing the work, and the lot owner who did the work didn't agree to the amount of work that had to be done to fix the problem. Perfect timing for NCAT. NCAT said the fact that the slurry escaped through common property into the applicant's lot meant that the Owners Corporation was liable, full stop. So that takes us back to 106. It's a strict liability. That's not to say the owners couldn't recover from the lot owner above who was doing the work, but the applicant, it didn't need to be his problem. He only had to worry about the Owners Corporation acting. So I chose that example because I'm sure we all have those situations too. And as much as it does not seem right for the Owners Corporation, and I know you've probably got committee members that you need to walk through how this works, because of the strict duty, the Owners Corporation will have to make good. So the applicant there was awarded the full amount of his loss and the lost rent. I think he ended up getting an award of about $24,000. The next one I've got on the slide is repairs for dummy tiles. I only put this one on because, firstly, I should distinguish it doesn't involve compensation, so it wouldn't be a policy 2 claim. But what is interesting as an example is how the disputes can arise. So in this case, the lot owner had identified lots of drummy tiles in his bathroom and his laundry, and I think his toilet as well. He asked the Owners Corporation to fix it, and the Owners Corporation agreed, but said there were only a few tiles that they had to repair. And the applicant argued that no, they were in fact the entire bathroom, toilet and laundry needed to be redone. The dispute was about the extent of work, which I've also seen in a number of claims, a dispute between various experts. Everyone gets their own expert to comment on the appropriate rectification method. It went to the tribunal, and the appeal panel held that because the tiles were the original tiles, they were fixtures of the common property, and it was the Owners Corporation's responsibility to repair. And the tribunal then made orders for all of the bathroom, laundry, toilet to be retiled. So I just flag that as a distinction and something to be mindful of. Going to now the next slide. I'll be conscious of the time and our agreement, our time contract. So I'll very quickly talk about what we see exploding is the loss of rent claims. The biggest decision settling the ability of NCAT to make awards is Vickery, and that involved a claim of about $97,000, which is certainly a significant amount of damages. What we are seeing now is that in NCAT, it's well accepted that if a lot owner suffers loss because of a breach by the Owners Corporation of 106, they will be able to have that loss, as long as it's reasonably foreseeable, they will be able to receive damages for it. And Vickery is sort of the authority for that. Pickard on the right-hand side of the screen is a more recent, it was only delivered a few months ago. And whilst it also accepted that, yes, rent and damages for loss of rent can be awarded by the tribunal, there is a time limit of 2 years within which to make the claim. So, and the 2 years runs from the date the applicant first becomes aware of the loss. So if your tenant moves out, or your tenant writes making a complaint about the water ingress or some other damage that has been caused by the Owners Corporation, that will be taken by the tribunal to be first awareness. It's really important in your roles to identify if you've ever been notified that there is damage or losses being incurred, that you make a record of that, because that will be critical in trying to defend a claim. So the case in Pickard, even though there was evidence that she lost rent because of the damage, she had waited too long. I think she first identified the damage in February 2020, which is when those big storms were, but didn't file her NCAT application until April 22, which was about 3 or 4 months out of time. So she wasn't successful. We'll move on now to the 2 years. This is the section in 106 which prescribes that you've got 2 years. So I'll give you a second to read that. When they first become aware of the loss. And being aware is when the loss of rental income first occurs, or when you might realise you've got to pay for new carpet, whenever there's a first notice of a complaint and steps are taken to address it. We'll go on to the next slide now. I'll be very quick with this one. I just wanted to identify that it's not always water ingress. This is an example of a faulty garage. You can get property damage claims arising out of this one, where a car has been damaged by a faulty garage door. Again, even though the Owners Corp might have retained a garage specialist to manage the operation of the garage, because it's common property, it rests with the Owners Corp to compensate anybody who sustained damage. What you can do, though, is recover after you've paid. You can bring a subrogated recovery against whoever is responsible for managing the garage. I'll move along now so that I can give you some tips on how to assist in the life of a claim. Now, we've talked about it as we've gone through. Make sure you get documents or records as quickly as possible. When there is an incident, whether it's a property damage or a personal injury, gather everything relevant to that incident. Make note of who would be useful witnesses to talk about. Notify your broker or insurer really, really quickly. And something that I really wanted to emphasize is, if you can work with your committee to nominate one person who might be the communicating conduit between us and you and the rest of the committee, that helps to drive workflows and updates. Vince mentioned before, sometimes you can get delay. It's really difficult for owners to make decisions about how to firstly repair and maintain, but also how to action rectification works. So it's really important that we can support them to make decisions quickly and explain the consequences of delay. And again, early resolution. So getting in early, identifying the problem. I think sometimes owners, corporations, maybe delay because they are worried about the cost of the works. but delay never actually makes the cost get any less. In fact, it's the opposite. Now I'll finish with some top tips. We talked about this, and certainly the photos that you would have seen from the personal injury claims and the water damage claims. Regular maintenance and inspection is key. So, it's a common theme that there's these hazards. We want you to be proactive. We want the owners' corporations to really make sure that they maintain their valuable property. We talked about a system of reporting. Again, it's really good to empower all of the residents to notify defects or hazards that they identify. Another good idea is to put work orders in place for specific things that you need or works done. So, for example, the case we had with Miss Borg, the building managers were also held liable because they were contracted to monitor and repair the common property. Review all your agency agreements, make sure that there are appropriate risk transfers to building managers, cleaners, gardeners, and then take regular time to identify hazards, analyse what the potential risks might be, for example, broken drains, and then evaluate the priority of addressing that. Finally, my last top tips are considering adopting the Common Property Memorandum. That can, in that Drummy tile case, that could have been the difference between paying for the entire rectification and just paying for a few. Consider bylaws that formally transfer obligations to a lot owner, particularly if there has been some internal renovations. Pursue third parties, builders, developers who might be responsible for the actual building defects. I know the Design Builders and Practitioner Act has changed the landscape a bit, and we should not be shy about pursuing essentially the wrongdoers who have caused the building defects. Other top tip that I'll leave you with is respond to requests for information as quickly as possible and keep the information flowing. These claims don't go away, and definitely in my experience, the longer they last, the more difficult they are to resolve and the more expensive they become. I'll wrap up then by saying let's approach this with common sense, and remember we're all humans and we're just all trying to get the best outcome. So I'm going to go back to Vince now. We've got like 2 minutes left.
Thank you for that, Al. And perhaps in the last minute, there was one quite interesting question that we might be able to touch on very quickly. Someone's asked, what about in a situation where a lot owner is doing some gardening work in a common area with the intention of saving the cost of using a professional gardener? If they become injured doing that, are they entitled to make a claim against the owner's corporation?
Oh, what a great question. They would be entitled to make a claim because they are injured on common property. Whether the owner's corporation would be held liable for that would really depend on, did they know she was undertaking that work? Did they direct her to do the work? Did she take it on her own volition? And if the owner's corporation asked her or knew she was doing that work, then it is their responsibility to make sure it's a safe space. And that's, and I know we don't have time to go into it today, that's where the work health and safety obligations come in as well. So yes, that is a risk.
Yeah, really interesting. Just before we wrap up, please remember that CHU have a great library of educational materials on our website, and that includes the ability to go back and watch any of these webinars on YouTube. Please also check out our series of videos on strata industry experts. We've got interactive videos on strata managers, brokers, underwriters, and make sure you check out the one on a claims consultant featuring our own Cara McInnes. Melissa, I'd like to thank you very much for your time today. That was an extremely interesting presentation. And thank you to all the guests for joining us. Any questions that haven't been answered will be sent out shortly, and certificates of attendance will be sent out in the next 7 days. There will be a further invite to our next webinar coming out soon, so keep an eye out for that. Thank you, everyone, and enjoy the rest of your day.
Thank you, Vince.